Good morning, Your Honors.
Good morning.
Jason Gishner on behalf of Mr. Hayes. It is my first time appearing before two of you, and I'm grateful to be here with you today.
Mr. Gishner.
Gishner.
All
yes,
right.
ma'am. And I would ask to reserve 4 minutes for rebuttal, please.
Great, you may proceed.
Thank you. Andrew Hayes has spent almost 2 decades in prison for a murder committed by someone else. And this is a conviction that is grounded upon the confession of a man with a 62 IQ who was interrogated for about 27 hours without the benefit of counsel. Now, we are not here today asking this court to overturn his conviction and let him out of prison. We are asking for much more limited relief. We are asking for a day in court to present new evidence never heard by anyone, which proves that Andrew is innocent and that someone else is guilty. The primary issue I'd like to discuss this morning is the trial court's misapplication of the Clardy decision by denying equitable tolling. And as such, I intend to talk about 3 things. The evidence in this case is new. Taken as true, this evidence is clear and convincing proof of innocence. And while the Clardy decision provides instruction for how to properly plead an error coram nobis case to achieve equitable tolling, it was not intended to keep legitimate cases of innocence from the courthouse. The decision in this case was error and is an outlier from the other error coram nobis cases that have been decided by this court since Clardy. I'd like to begin and end by talking about Clardy and what it said. The Clardy decision emphasized that there's a distinction between the pleading requirement to achieve equitable tolling and the merits analysis for relief. To meet the pleading requirement in cases like this one, a petitioner must present newly discovered evidence that, if credited, clearly and convincingly proves innocence, and the evidence must be presented within a year of its discovery. Now, in this case, the trial court found that Mr. Hayes met the 3rd requirement. The petition evidence was presented within a year of its discovery. What we need to talk about today is why the evidence in this case is new and satisfies the clear and convincing pleading standard. And it's important to keep in mind what the Supreme Court said about this kind of evidence at the tolling stage. The coram nobis court should assume arguendo the veracity of the new evidence cited in the coram nobis petition for the purpose of assessing whether to toll the statute of limitations. Now, a little bit of factual background about this case I think is helpful as we consider the new evidence. There were 2 competing theories that were presented at the trial in this case. The state argued that Tammy Vance and Andrew Hayes committed this murder, and the defense argued that Tammy Vance and Sarah Lucas committed the murder. There wasn't any physical evidence that tied Andrew Hayes to this case. As I said earlier, he was essentially convicted based on his confession. In fact, to quote the lead detective of the case at trial, "I don't know of anything that links him specifically to the crime other than his confession, but that's compelling enough for me." And when we talk about the confession, I've already mentioned that this is a man with pretty significant cognitive disabilities, but it's also important to keep in mind what he actually confessed to. After 27 hours, Andrew Hayes confessed to hitting the victim in the back of the head on the 2nd story of the victim's apartment 2 weeks prior to his interrogation. None of that is true. The victim in this case was not hit in the back of the head. He lived in a 1-story apartment, and the murder in this case happened months before Andrew Hayes was ever interrogated. So we have a man essentially convicted based upon a confession that is objectively untrue under circumstances that I would argue were coercive.
Didn't he mention that Tammy Vance threw a container of bleach at the victim?
I'm sorry?
In his confession, didn't the defendant say that Ms. Vance had thrown a container of bleach?
So there are parts of his confession that the officer testified that Andrew Hayes said. I would point out that this interrogation was neither video nor audio recorded, despite the fact that he was in custody for 27 hours. So there are aspects that the police said he said that are consistent with things at the crime scene. There are other things that the police say he said that are objectively untrue with evidence from the crime scene. So yes, it's fair to say that according to the police, he said things that were consistent with evidence at the crime scene. That's fair.
Okay, for purposes of this appeal, that you're arguing, basically, you're making a sufficiency of the evidence argument. That's been rejected. You know that.
I do, and I only point that out, Your Honor, because I think the context of that information is important, particularly when we talk about what the new evidence in this case and how that new evidence applies to that context. So let me talk about that.
Please.
First of all, we have 5 new witnesses that are willing to come to court that say that Sarah Lucas confessed to this crime.
Do any of those witnesses have firsthand knowledge that Mr. Hayes did not commit this offense.
So Tyler Landers does.
Firsthand knowledge.
Yeah, he overheard a conversation, which is in his affidavit, between Sarah Lucas and his mother, Heather Balderas, who was Sarah
How is that
Lucas'
firsthand
sister.
knowledge? That is
Well, he has firsthand knowledge
double
of the confession.
hearsay.
Well, he heard her say that she committed the crime.
Would he be able to testify to that in
Yes.
court? How?
So let me address the admissibility arguments.
Please.
So I would say that there are a variety of reasons why the evidence in this case is admissible. First of all, I would say that the alleged hearsay isn't being offered for the truth of the matter asserted. It's being offered to show that Sarah Lucas committed the crime, not that Andrew
If
Hayes
it's
is
not
innocent.
being offered for the truth of the matter asserted, then what is the point of putting it in error coram nobis affidavit?
Well, certainly I believe the substance of it, that she committed the crime, but it's also being offered to show that all of these specific facts that these witnesses have to say are true. But let me even talk about the hearsay exceptions and beyond the hearsay exceptions, why it's admissible. So let's look at Rule 804, all right, which is the admissibility of evidence when it's hearsay coming through an unavailable witness. Heather Balderas is deceased, okay? So she can't come and testify. Heather Balderas was involved in this crime. She was called from the crime scene from her sister within 20 minutes. She was called from the victim's cell phone like 50 times in the 2 weeks following the murder. I don't think there's any question that she was involved with her mother and her sister taking money out of the victim's ATM account, talking to them about covering up the crime scene. No question that.
Okay, I'll even give you that. I'll go there with you.
Okay.
But how does that disprove the defendant's guilt
So
and show that he's actually innocent?
the overwhelming evidence in this case was one of two things, which is either Tammy Vance and Sarah Lucas did this, or Tammy Vance and Andrew Hayes did this. This isn't a Clardy case, right, where you have multiple people. So the argument in Clardy was, well, he could have been one of those two.
I was reversed
I
in
know.
Clardy.
I was
so
at
I know.
Austin Peay when that was argued in front of you, and still represent Thomas Clardy, so I'm very familiar with it. But it's not that case, right? I mean, the evidence in this case is that it was either Andrew Hayes and Tammy Vance, or it was Sarah Lucas and Tammy Vance. It's one or the other. So if there's no question that Tammy Vance did it, I don't think anybody doubts all of the overwhelming evidence from both sides that she was part of
so
this.
you're throwing names at me. Mother, daughter, which would give
Tammy
me.
Vance's mother, Sarah Lucas's daughter.
Okay, and then your other.
Andrew Hayes, my client.
Right, I know who your client is, but you threw some other names out there. If you could just communicate, because I get lost in the names.
Sure.
The mother basically pled guilty as well, claiming for the benefit of our analysis here that she was taking the charge for her daughter.
Correct.
And the daughter denies anything in all the affidavits that you submitted in this petition. She denies any involvement in this whatsoever, says mother is crazy as a loon.
Correct.
Okay, so I just want to be clear about what we're talking about.
But let's talk about why the daughter's position on that is not believable, particularly in light of the new evidence. So
you're asking this court to make credibility determinations about a witness in an affidavit?
I'm asking this court, per Clardy, to assume what these people say is true and that their credibility should be tested at a hearing.
Clardy doesn't require us to get to that point until you establish in your petition that the evidence is new evidence, which presupposes that it is admissible. You've not demonstrated that yet.
So let me talk about why the evidence is admissible. So these other people are going to come to court and they're going to say, Sarah Lucas has admitted she committed this crime, and they're going to discuss the circumstances of how she committed the crime. They are going to say that she hit the victim in the head with a hammer. They are going to say that she stole his truck.
Wait a minute. You've lost me. So this again is going to the daughter being
Correct.
guilty
The
of the
daughter,
offense.
Sarah Lucas.
Okay, so again, this is not going to actual innocence of the defendant.
If we prove that Sarah Lucas is the murderer, it follows that Andrew Hayes was not, because it is either one or the other.
How is it necessarily one or the other?
Under everything we know about the facts of this case, the state's, it's always been that two people committed this crime, but let me even speak to objective physical evidence why we know that it was Sarah Lucas and Tammy Vance at the victim's apartment the morning that he was murdered, all right, and not Andrew Hayes. We have cell tower records from that morning that were never presented to a jury. And what we can establish through those records is that on the morning of the murder, Sarah Lucas and Tammy Vance were in the victim's apartment when he was killed. 20 minutes later, from the victim's apartment, with his cell phone, the first call is made to Sarah Lucas's brother, a man named Miguel, boyfriend, a man named Miguel Famat. The second phone call is made to her sister, Heather Balderas. Later that afternoon, his ATM card is used to steal money from his account. Within days of this, Sarah Lucas is pawning his stolen property at pawn shops that she lies to the police about. And we can prove through the cell tower records that they were in that apartment. The other reason we know that they were together that morning is that we can prove through cell tower records that the victim is in West Memphis, Arkansas, about an hour and a half before he's killed, at the same exact location where Sarah Lucas is, getting her state driver's license identification. And she's there with him. And all of these other witnesses are going to come to court and say she has made admissions consistent with this information. Not only does the cell tower data show that Andrew Hayes isn't there that morning, Andrew Hayes doesn't even meet these people for like another month when they move into the apartment to live with a woman named Janice Jefferson, that he was also living in that house. So
how are Ms. Lucas's statements to these new witnesses, how are those admissible?
Well, I would argue that it's admissible because under 804, but I would also argue that under a Chambers analysis, these statements are admissible. So Chambers, which was incorporated in Tennessee by the Brown case, says that evidence is admissible despite potentially being hearsay if it's crucial to the defense, reliable, and the balance of interest for inclusion outweighs exclusion. And what I would say is that Chambers specifically states, excluding evidence of a third-party confession violates due process. So I believe that all of this is admissible on its face. I would say at a minimum, if there is a question about admissibility, that's a reason why you have a hearing and you hear what the evidence is and conduct a Chambers analysis when you can assess the credibility of the witnesses and hear what they have to say.
What's your take? How much does clarity allow the trial court to look at admissibility? We know, we set credibility aside, we assume arguendo that they are credible, but what about admissibility?
I think it's a little bit of an open question. I mean, the Logan decision speaks to that issue about admissibility, but Logan was decided pre-Clardy. I would argue that the admissibility question should be part of the merits analysis, but I also think you're going to be stuck with cases like this one.
But Clardy cited Wilson with approval, and Wilson specifically says it has to be admissible. I mean, that's the whole point of the statute. It presupposes that the evidence that's pled in the petition is admissible. And I'm sympathetic to your argument. But that is what our law says. Clardy cited Wilson, period, point blank, and they're interpreting the statute, explicitly the statute, that presupposes admissibility.
Right, but what I would say in response to that is that the admissibility question can't always be resolved just by looking at the pleadings, right? Because there are cases where you have to do a Chambers analysis where you have to actually see if you believe these people to see if it qualifies under Chambers. Now, I would argue that the evidence in this case is admissible on its face under Rule 804. I would also argue that it is admissible on its face under Chambers. So I believe we have met admissibility. I would also argue to this court that there is new evidence beyond just these new witnesses. There is new scientific evidence that is related to the coercive interrogation that's incredibly powerful and relevant in the case.
What is the new evidence regarding coercive interrogation?
There's an expert that will testify to the psychology of the coercive nature of the investigation.
Was that not available at the time of trial?
So the science itself could have been available, but the developments since this trial in 2010 are extensive. And the report is in the petition, so you can see what's cited in the report.
Because, correct me if I'm wrong, it was contested. The admissibility of the confession was heavily contested pre-trial.
It was, and I'm not making an argument related to the suppression of the confession.
I understand.
Yeah, you're right. It was contested, and the court ruled that it was admissible. But I would argue what's important about this new scientific evidence is the developments in the science related to the coercive interrogation, particularly in a case like this where you have somebody that's convicted pretty much entirely based on his confession. So a couple other points I want to quickly make.
Sure, I know you're running.
I know you're asking
questions.
important questions. Unfortunately, there are a lot of issues in this case. But I think it's also important to talk about the basis of the denial by the trial court in this case.
And the trial court here issued a 38-page opinion, okay? She was meticulous in addressing the analysis in clarity, alternative analysis. So I need for you to really narrow down what you think the trial court did wrong here.
Sure. So the trial court didn't even address the admissibility issue. The trial court said, this doesn't mean equitable tolling because it's cumulative for the purposes of impeachment, all right? The problem with the trial court's analysis is that it only went halfway in its analysis. What the court said is that newly discovered evidence, which is simply cumulative to other evidence in the record, will not justify relief. Now,
Why isn't that enough?
because it only goes halfway. And if we look at the Appellant decision, what the rest of that sentence is, when the evidence might not have resulted in a different outcome. So what the case law is saying is that if you have evidence that is either cumulative or impeachment, but it is strong enough, particularly when it's evidence of somebody else confessing to a murder, that is good enough for error quorum nobis relief. And let me also quote what Justice Koch said in Harris versus State. There's no question that an authentic confession by a third party to a murder is critical to a person's defense in the context of error quorum nobis analysis. And let me also point out, as it relates to impeachment, what the Tennessee Supreme Court said in the Vasquez decision. Impeachment evidence might be particularly compelling under the circumstances of a particular case. Moreover, a complete restriction on the availability of quorum nobis relief in the case of any newly discovered impeachment evidence would be inconsistent with the discretion afforded to trial courts. And of course, the language in Tennessee Code annotated 4026-105 makes no distinction between impeachment evidence and all other evidence. Thus, the ultimate question is the effect of the newly discovered evidence in the outcome. So what the trial court said in this case is, this evidence is cumulative for impeachment purposes, and that's not a basis for error quorum nobis relief. That's not what Vasquez says. That's not what Avent says. That's not what Teague or Woldor say. The evidence has to be good enough. Now, the other question is whether the evidence qualifies as clear and convincing evidence of innocence. And I think the best way to answer this question is look at the other decisions that have come down from this court post-Clardy on this question of who meets equitable tolling and gets a hearing and who doesn't, all right? The cases where we see courts granting equitable tolling have less new evidence of innocence than this one. In the Garner decision, where you have...
You need to wind it down.
Okay, sorry, I know I'm over.
Yeah, yeah.
I can talk about this in rebuttal, but the only point I would make about this is that Garner, McKissick, Avent, these are all cases that have less evidence, new evidence of innocence than we have in this case that results in equitable tolling and a hearing, which is why there should be a hearing in this case.
Thank you, counsel.
Thank you.
General? It's good to see you, General Coleman.
Good morning, Your Honors, for the next 6 minutes or so. And may it please the court, Ronald Coleman on behalf of the state. This court should affirm the denial of quorum nobis relief because the quorum nobis court properly found that this untimely petition did not warrant tolling. Before I get into sort of that, I do want to provide a little bit of a factual background. I think it's important to, not just for the victims that are watching, but also just to contextualize things. So on August 20th in 2007, the defendant beat the victim to death with an iron pipe. The proof at trial showed that police questioned the defendant, and he gave details that they said only the perpetrator could know before he ultimately confessed to the murder. He told a number of unique details that they found to be suspicious and indicative of his involvement. but ultimately told them that he hit the victim in the head with an iron pipe, that he did so multiple times. He talked about this co-defendant, the mother named Vance, how she shoved a rag into the victim's mouth. He also talked about how that she eventually tossed some bleach onto the victim after he was deceased, and provided other details as well. Police were able to corroborate this confession. They said that the crime scene evidence, the forensic evidence inside, corroborated the fact that this victim had been hit multiple times in the head with a large blunt object like an iron pipe. And then it's important to note, further contextualizing this statement, police started to take a formal statement after the defendant had confessed to his involvement, and the defendant changed stories a little bit, but it's important to note that he always said that he was still present. He tried to blame, I think, 4 separate individuals as being the one who landed the lethal blow, but never said, well, I was never actually there. Always said he continued to be there. And then the following day, when police came back and interrogated him again, he once again admitted to murdering the victim by hitting him with a metal pipe in the head multiple times. Again, this was corroborated, and what was also corroborated is that at some point shortly thereafter, he was seen carrying the victim's large television back to his house. Despite all of this proof, the defendant still was able to present a vigorous defense at trial. He had a doctor testify that he had a somewhat low IQ. His former girlfriend attempted to lay the blame with the co-defendant, Vance, and with Vance's daughter named Lucas, tried to say it was them. The defendant testified on his own behalf. He, in fact, presented just how vigorously the police interrogated him and sort of complained that he never meant to confess, he just didn't really know. So he told the jury this information, and then the co-defendant, Vance, testified on his behalf and explicitly told the jury, I was throwing him under the bus to save my daughter Lucas. Lucas is the one who did it. The jury discredited these witnesses and found the defendant guilty of first-degree murder. Now the defendant seeks coram nobis relief on a number of different pieces of information. But the first and penultimate question that we're here for is whether he's even entitled to tolling the statute of limitations. And Clardy, our Supreme Court, clarified what a defendant has to do to establish tolling. And I think it's important that the 2 points that the defendant cannot make here. First, he cannot establish that the information presented was newly discovered evidence. And second, he cannot establish that this was proof of actual innocence. So first, I believe, Judge Hickson, you asked, how much do we look at admissibility when we're looking at the tolling analysis? And it's important that Clardy used a term of art, newly discovered evidence, which has been defined by the courts. It's not just that it's new. To be newly discovered evidence, it has 3 requirements. It has to exist but not yet be ascertained at the time of trial. It has to be admissible, and it has to be credible. Now, Clardy said we sort of presume that third prong. That we just kind of, when we're looking at this threshold issue of tolling, we presume that it's credible, but it still has to meet the definition of newly discovered evidence. So it either has to have existed at the time of trial, or it has to, be admissible. None of this new information that the defendant submitted with his coram nobis is either of those, or is both of those. To Judge McMullen, your point, with these new witnesses and these affidavits, none of this is admissible. This is hearsay, sometimes hearsay within hearsay, and the defendant did not present any argument below, at least my understanding of the record. I am filling in for Davy Douglas, so the record is more accurate, but my recollection is he didn't even argue that this met the burden of admissibility under any rule or statute or
What about
case.
his argument here today that Ms. Lucas's third-party confession would be admissible under Chambers and Brown?
I think because it's still hearsay, it would be precluded. And even if it weren't, even if it sort of constituted newly discovered evidence, it still doesn't meet the second prong of actual innocence. Again, the defendant, even when he attempted to sort of recant his confession, always stated that he was present. And the defendant sort of seems to make this logical leap that if Lucas was involved, the daughter was involved, then inherently he just simply could not have been. That's not what the proof shows, and that's not, there's nothing here that negates the defendant's involvement or shows a clear lack of involvement. This isn't an alibi where someone said, oh, I was actually with him at the time, because we know exactly when the murder was. The victim here had a pacemaker, and so we can tell the exact moment that he passed away, or that he was murdered. We don't have evidence of actual innocence saying the defendant was actually with me on that day at this time. Instead, what we have is cumulative impeachment evidence of, even if it came in, it just would bolster his defense, which he vigorously presented at trial. I think one thing that he says too, that I want to point out is that the court only went halfway with regard to this cumulative impeachment evidence. He misconstrues the standards because we're doing two different tests. I don't think Vasquez or any of the other cases that he cites deals with whether tolling is appropriate. And if we are looking at the merits after tolling or if under a timely petition, then maybe, because I think what the Supreme Court is saying is you're not precluded from ever having impeachment evidence or cumulative evidence that could or might change the outcome. But here, we have a higher bar under Clardy, and that bar is clear and convincing evidence of actual innocence. It's not that this might have changed the outcome at trial. It is that this is clear and convincing evidence that he did not do the offense that he's convicted of, and the defendant simply can't meet that burden. So the state's position is, first and foremost, none of this information is newly discovered. These witnesses, it's all hearsay, none of it's admissible. The defendant hasn't established that it's admissible. And some of the other things I want to talk about is this new scientific evidence that he mentioned today. To your point, Judge McMullen, this was already known at the time of trial. In fact, trial counsel commented at post-conviction that he thought about getting an expert to help with his suppression issue. And my friend on the other side seems to have countered that, well, these are developments that have happened since the trial was completed. But that goes back to newly discovered evidence, which has to be existing but not yet ascertained at the time of the trial. So if the reason that this is newly discovered is because it happened after the trial, then it is inherently not newly discovered evidence. And then last, I think the only other thing that he talked about today was these cell phone tower records. That's not newly discovered evidence. That's not even evidence considered in the Coram Nobis petition. He's not attached that. He asked this court to sort of consider it in context with other proof at trial and post-conviction because it was in the state's file. But he relies on a case that seems to find that you were allowed to consider Brady evidence that was improperly withheld from a defendant. This was in the state's file. There's been no finding that it was improperly withheld. It just wasn't presented to the jury. So these cell tower records cannot be considered at all, but certainly they're not part of the Coram Nobis petition. I think those are the only points that were discussed today. Unless this court has further questions, I'm happy to rely on the remainder of my brief. But again, none of this information is newly discovered evidence. None of this information is evidence of actual innocence. For that reason, the post-conviction or the Coram Nobis court properly found that the untimely petition did not warrant tolling. We ask that you affirm.
Thank you, counsel.
Thank you.
Mr. Gershner?
Thank you. Let me respond on just a few of those points. So first of all, Chambers and Brown are hearsay cases. That's what those cases are about. You know, if you have a third-party confession, if it's hearsay, due process tells us we should still hear that third-party confession, which is why the evidence is admissible in this case, because all of these people will come to court and say someone else confessed to the murder. The second point I would make is that...
I'm sorry.
Go ahead.
Who is going to say that Miss Lucas confessed that she did it? And how does that clearly and convincingly demonstrate that the defendant, Mr. Hayes, did not?
So all of the people who will come in are Miss Lucas's family members. These are people who don't know Andrew Hayes. They've never met Andrew Hayes. They don't know anything about him. They know because either they heard her say it or they heard it from their mother who's deceased that she confessed to it. So these are all her family that will come in and say it. And then let me address your second point, which I think is important. And this is why the other evidence, the cell tower data, is important because it provides context to this new evidence. And first of all, these were exhibits to the petition that were filed. So this is all part of the record that's before the court. What that cell tower data proves is that on the morning of the murder, and counsel's right, we know exactly when this person was killed because he had a pacemaker. We know where he was because we can track him through his cell tower records and cell phone, and we know who was with him. So we can see through those records that when he was killed, he was with Tammy Vance and he was with Sarah Lucas, and he was not with Andrew Hayes. That's why all of that information matters, because it provides context to these family members who are going to come in and say she confessed to it.
Is that because the record shows that Mr. Hayes is elsewhere at that time?
Well, we can see that he's not, we can follow the cell phone that morning, and we can see the stops that are made, and we can compare and contrast that to the trial testimony of Tammy Vance and Sarah Lucas and see where they were. So what we can see from these records is they start out that morning in Cordova, which is exactly what Ms. Vance says. They drive over to her daughter Sarah Lucas's house and pick her up. We can see it in the cell tower records. They go to West Memphis, Arkansas. We can see it in the cell tower records, and it's confirmed by the identification that Sarah Lucas got at the DMV that morning. And then we see them drive back to the apartment, not stopping at Sarah Lucas's place, and within a very short period of time of that, the victim is killed. And then within 20 minutes of that, his cell phone starts calling Sarah Lucas's boyfriend and Sarah Lucas's sister. And nowhere on that map do we see any stops or any connection to Andrew Hayes. We also know that Andrew Hayes doesn't meet these people for weeks until after this event. So we can track that evidence. So how does it get in? And this gets to the Johnson case the counsel was just asking about, saying this isn't admissible. I would argue that this court should consider the entire record of the case. And that's what Johnson says. It's not just about evidence that is withheld as a Brady violation. It's the spirit of, let's get to the truth of this thing, right? I mean, that's what the McKissick case says too. We should look at the entire record. And if we have objective physical evidence that shows two people with the man when he's murdered, and we use that as context for 5 witnesses who are family members of these people who are going to say that one of them confessed to this murder.
But I understand your time's about to run, but those 5 family members are going to say exactly what the mother testified to at the defendant's trial. And that is, she was covering for the daughter, because the daughter is the one who actually did this. That was testimony at trial that the jury rejected. And that, to me, is part of what the Air Quorum Nobis court was trying to say. This is all basically cumulative of what mother testified to at trial.
So they have information beyond what mother said about the financial arrangement, about the circumstances of how the murder happened. But what I would argue, Your Honor, is that if the evidence presented at trial was true and rejected by the jury, and it proves that he was innocent, and we have lots of people after the fact that are going to come in and say, you got it wrong because this person has confessed to committing the crime, and we know the details and circumstances of how she did it, and we can back that up with objective physical evidence that proves it's true, and she did it, and this other guy didn't, that should meet equitable tolling for the purposes of having a hearing. We are not asking you to turn him loose or overturn this conviction. All we're saying is that there is a mountain of evidence in this case that the wrong person is in prison, and he can't even get a day in court. That shouldn't be where we are. It is also inconsistent with all of these other cases post-Clardy, where people have less new evidence of innocence that has resulted in equitable tolling and has resulted in hearings, which is why this case is an outlier, and we would ask this court to find equitable tolling and remand it for a hearing.
Thank you, counsel.
Thank you.
Well argued, well briefed. The matter will be taken under advisement. I think that concludes our morning docket. We'll be in recess until lunch until our 1:30 docket.
All right.